Good evening. I'd like to call the meeting of September the 18th for the Pitt County Planning Board to order. And at this time, I want to welcome all of you that are in the audience and those that are at home watching my TV. It's good to have our Commissioner Colson here tonight, and we thank all of you for coming. At this time, would our clerk call the roll, please?
Faye Barefoot,
Present.
Frank Bradham,
Here.
Jacob Cox,
Here.
Lyman Hardy,
Here.
Wanda Harrington,
Here.
Thomas Harris,
Here.
Clay Malloy,
Here.
Matt Nobles,
Here.
Kenneth Ross,
Here.
and William Wooten.
Thank you. At this time, let us stand and we'll have the prayer by Mr. Browder and the Pledge of Allegiance by Mr. Hardy.
Let us pray. Dear God, thank you for allowing us to live in the United States of America, the freest country in the entire world. We're lucky to be living here. Bless this board that we will have the wisdom to make the correct decisions on behalf of the citizens of Pitt County. Bless this entire nation and help us find ways that we can stop the tragedies that seem to be occurring all too often in this country. Go with us each and every day and give us the wisdom and the power to go out and help our fellow man. In his name we pray. Amen.
Face the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
At this time, you have your minutes with you from your packet, and I also have an amendment to acceptance of the minutes. Before we accept them, there's an additional comment that needs to be added, and each of you have that. So we'll take a motion if you do not have any questions about this amendment to the motion. To the minutes.
Motion to approve the amendment and the meetings.
Second.
Okay, all in favor?
Aye.
Aye. All right, at this time, we have two public hearings, and I'm going to turn it over to Matt for the first one, subdivision ordinance amendment, the street maintenance requirements, okay?
Thank you, Madam Chair. Again, the public hearing is on the proposed subdivision ordinance amendments regarding street maintenance. To give you some background, as a refresher, in December of 2012, we made subdivision ordinance amendments specifying a developer's responsibility to construct and maintain subdivision streets until DOT took them over, maintain them until DOT takes them over. In March 2013, the Planning Board recommended additional amendments regarding street maintenance guarantees. The planning board forwarded them to the Board of Commissioners, and the Commissioners did not adopt those at that time and recommended the formation of a street maintenance committee that was charged to develop a recommendation which would be brought back to the Pitt County Board of Commissioners that would guarantee streets and subdivisions are built and maintained to DOT standards until taken over by DOT, and it be done in a way that is acceptable to developers and fully protects homeowners from street maintenance liability. This committee met 4 times from May through July of this year, and they received staff presentations on the existing problem and what other counties are doing to enforce street maintenance. And the committee received presentations and discussed what works well for what may or may not work well for Pitt County. The committee came up with a 3-point approach. The financial guarantee portion was recommended again. It was a lesser percentage. The original committee, or the original presentation, was 25%. This time they recommended 15%. Also, an annual inspection and reporting program and maintenance violations are now enforced as subdivision ordinance violations. committee expressed unanimous support for this three-point approach. However, they did have a split vote over the percentage of the financial guarantee. 5 of the members wanted 15%. 4 of the members wanted either to leave that recommendation up to the Board of Commissioners or a higher percentage. Per the Street Committee's recommendation, staff proposed to add the following amendment language to the Pitt County subdivision ordinance. I'm not going to read the whole thing. I'm just going to kind of hit the high points of the language. Again, the first part is the road maintenance guarantees. That's the basis for all of this. The developer is going to submit a financial guarantee for 15% of the total cost of the road construction, so that the roads can be maintained after the project is constructed. The guarantee is released back to the developer once NCDOT takes the road over. Acceptable forms are letters of credit, performance bonds, cash escrows, or any other method allowed by North Carolina General Statutes 153A through 31. The county will get a letter from DOT stating that they have taken over the road before the county releases the guarantee back to the developer. The annual inspection program. The developer, once they build the road out and start building houses and everything, each year they'll submit a report to the county stating the condition of the roads. They'll also go through how many houses are built in the subdivision, so that once that neighborhood meets DOT's density requirements, DOT can then adopt the road. The developer's engineer will compile the report, the county will verify it. And they'll identify any maintenance problems and then fix them within a specified amount of time. And as to what that report will cover, it'll cover all road construction until DOT adopts it. Street right-of-way improvements, the road surface, roadside ditches, and drainage improvements. If the county determines that there is a road maintenance violation, the county will start enforcing those road maintenance violations as subdivision ordinance violations. And the subdivision ordinance now allows for penalties in there under section 164, I believe, per day until those violations are corrected. And if the violations go on for an extended amount of time, that's when the county can use the financial guarantee that they provided for when they built the roads. We propose also to add the following commentary to Appendix 6 of the subdivision ordinance. And I'll hit the high spots on that. In researching street maintenance responsibility, legal staff determined that the ordinance did not explicitly state a developer's responsibility to maintain streets. It was implied through certificates or on recorded maps, but not stated explicitly in the ordinance. This was for the December 2012 amendments. Also, the next one was for the 2012 amendments. Next commentary talks about the financial guarantees, the annual inspection program, and maintenance violations. Staff recommendation: hold tonight's public hearing and forward draft amendment language to the Board of County Commissioners with a favorable recommendation. And I'll take any questions you have. Otherwise, we can open up public hearing.
Any questions by the board to Mr. Spicer? Okay. All right, at this time, we'll open it up for the public hearing. Is there anyone to speak at this time?
Miss Nancy Colville.
Okay. Ms. Culver, just come right on up, state your name and You have 3 minutes. Okay?
My name is Nancy Colville, and I want to speak in favor of this. It's a long time overdue. I really think the committee did an excellent job, and it's hard to balance what the developer wants and what the homeowners want. I think that 15%, it's reasonable. It can always go up if needed. There is two things that I would like for this board to consider maybe at a later date. And one of them would be like a developer's report card. It will be something that will sort of, since you are going to annually review the subdivisions and the condition and who's complying and who's not, then perhaps you, through the attorneys, the county attorneys, you can figure out a way that you could, the citizens could look at the performance of these developers, and, you know, some of them do a great job, most of them do, but there are some that seem to be consistent in falling by the wayside, and somehow the public should be made aware of who is and who isn't. I think that would be helpful. And the other thing I think would be helpful is to educate home buyers, because the buyer beware, and at closing time, perhaps when they're purchasing a home in a subdivision, there should be a statement provided by them or signed by them that tells them about the roads and maintenance and things, and where to go look and who to call, and so that they would better understand when they faced with a problem like street maintenance. So those are my suggestions and my comments. I've been around a long time in Bolton, and I remember what happened with Woodridge. I'm sure some of you remember. And so the county really, like I said, long overdue on doing really something right, because I remember how stressful it was for the homeowners of Woodridge. I also remember how expensive it was for the county. And, that does not need to be happening. Thank you. Appreciate it.
Thank you so much. Is there anyone else that would like to speak at this time? I declare that it's closed then, and we will have some discussion by the board, if there's any discussion from the board at this time.
Make a motion to approve.
Motion to approve by
Second.
seconded. All in favor, raise your right hand.
Thank you, Madam Chair.
All right. Next, we have the public hearing with Mark Nottingham. We'll bring that up. It's the zoning ordinance amendments for the Board of Adjustments, okay?
Yes, ma'am. Thank you, Madam Chair, planning board members. You just heard about some subdivision ordinance amendments. I'm going to talk to you about some zoning ordinance amendments. On June 19th of this year, Governor McCrory signed House Bill 276 into law with an effective date of October 1st of this year, and it affects our zoning board of adjustment. And as a reminder, that board is made up of 5 regular members and 2 alternates, and they vote on special use permits and variances and appeals. The first change is the fact that the General Statute 153A 345 that used to give us the county the power for the Board of Adjustment has been repealed, and it's replaced by 168 388, and that applies to both cities and counties. So throughout our zoning ordinance, that general statute number has been changed, or will be changed. The next amendment is to the voting section and the preamble. CUPs, SUPs, those are conditional use permits and special use permits. And any other quasi-judicial decision will be decided upon using a simple majority vote. And variances must have a 4/5 vote for approval. This is one of the major changes that's come from the general statute, and you'll see it in a couple other parts of our zoning ordinance. There are a couple other amendments that mention about the same thing. Conditional use permits have been decided by a simple majority, but those are heard by the Board of County Commissioners. The next amendment is to permits and hearing procedures. Under public hearing requirements and procedures, the statute now requires a notification of adjacent property owners for public hearings, and notices are also now required to be posted in the vicinity of the subject property. This is something that the county has been doing in the past, but now it is required. And it's also something that is mentioned throughout our ordinance, and you'll see other amendments about this as well. Next amendment is to the preamble under appeals, variances, interpretations, variances. The term practical difficulties has been removed. The courts have said that practical difficulties and unnecessary hardships mean the same thing, so both are not needed. And the purpose of the rewrite of the general statute was kind of clean up the language, so this is, one thing that does that. Next amendment is to Section 2C2D for Board of Adjustment. The board can no longer interpret the zoning map, disputed boundary lines, and lot lines. The zoning map and boundary lines are determined by the zoning administrator, and his decision can be appealed to the Board of Adjustment. And lot lines are decided upon by the courts if they're disputed. And that's also, one of the major changes is listed a couple places in our zoning ordinance. So there's a couple amendments that, deal with this. Next amendment is to Section 2C7, Board of Adjustment. The Board of Adjustment shall use a vote of 4/5 to grant a variance and majority vote for any other action. That goes back to the voting change. And the next amendment is to Section 3, M3, public hearing requirements and procedures. The time frame for mailed notices of hearings is now specified. The notice must be mailed at least 10 days, but not more than 25 days prior to the date of the hearing. The next amendment is to Section 3M4, public hearing requirements and procedures. This goes back to, the requirement of posting the notice in the vicinity of the subject property, which county has been doing. And the next amendment is to Section 3N2, SUPs and CUPs. The board shall use a vote of 4/5 to grant a variance and a majority vote for any other action. Next amendment is to Section 3 on SUPs and CUPs. The board can no longer take separate votes on each requirement not met by the application. The application is considered as a whole, and if one or more requirements of the ordinance is not met, the application shall be denied. This is just more of a formatting amendment, moving the solar energy facility standards alphabetically up above a solid waste facility. And the following amendment is to Section 11, judicial review. Every quasi-judicial decision shall be subject to review by the Superior Court of Pitt County, where it used to say every decision. The next amendments are to Section 13 for appeals. Any person with standing to appeal shall have 30 days from receipt of any actual or constructive notice of the decision within which to file an appeal. And the landowner or applicant may choose to post a sign notifying the world of the decision. The best way to describe this is with an example of a landowner getting a zoning permit to build something on his property, and instead of not knowing exactly when the appeal period is ended to start construction, he can put a sign out there, and then that 30 days starts from the day of the posting of the sign. So he doesn't spend a bunch of money on a contractor or materials and then have to halt it when the appeal is filed. Also under that section, all records regarding the appealed action shall be provided to the appellant and/or landowner. Appellant may request an expedited hearing, and the parties to an appeal may agree to mediation or other forms of alternative dispute resolution. The next amendment is to variances. It shall not be necessary to demonstrate that without a variance, no reasonable use can be made of the property. This is one of the other major changes, and it gives the Board of Adjustment a little bit more freedom to look at other circumstances or conditions as far as granting a variance. It'd be hard to prove that someone could no longer have a reasonable use of any of their property. So this takes that condition out. And next amendment is to Section 13, interpretations. The Board of Adjustment is no longer authorized to interpret zoning maps, disputed lot lines, and district boundaries. I mentioned that before. And this next amendment, Section 13, goes back to the voting change. And the amendment to Section 13H goes back to the notice of the hearing. Notice is required to be posted in the vicinity of the subject property, and a copy of the mail notice will be affixed to the sign. Deals with the same thing in Section 14. The general statute specified that signs will be posted and not necessarily notices. What we're going to plan to do is put the copy of the mail notice on the sign. That way the interested parties can look at the exactly what the case is about, the date and time of the hearing. Instead of, you see the signs now that might just say special use request and our phone number on there. And Section 15 deals with the boards no longer has the authority to interpret district boundaries. And the last amendment is to the appendix. The special use permit appeals and variance flow charts, they reflect the changes in the voting, where it's 4/5 vote required to grant a variance and simple majority vote for all other decisions. Unless you have any other questions, our staff recommendation is to hold tonight's scheduled public hearing and forward a draft amendment language to the county commissioners.
Right. At this time, is there anyone in the audience that would like to speak? At this time, I don't see anyone. We have no one to speak, okay. All right. Is there any questions or comment? I declare the public hearing closed. Now, is there anybody from the board that would like to ask questions, discuss it? Any questions? Do we have a motion to,
Madam Chairman, I make a motion that we approve the, for recommendation to the Board of Commissioners, these recommendations.
do we have a second?
Second.
All in favor, raise your right hand. All righty, thank you.
Thank you.
Okay, at this time, we have some administrative matters which Jonas Hill will take care of.
Thank you. Planning board appointments and reappointments. I went to the September 16th Board of County Commissioners meeting, at which Mr. Lyman Hardy was reappointed to his term. However, the other two reappointments were tabled at that meeting. So that has to be re-advertised, and will go back before the board at the October 24th meeting for appointment. So stay tuned as to who's gonna receive that. Would like to recognize Ms. Barefoot for her service. We have a certificate here for her. It says, presented to Faye Barefoot in grateful appreciation and outstanding dedication while serving as chairman, vice chairman, or regular member of the Pitt County Planning Board from September 2007 through September 2013. So I would like to thank Ms. Barefoot for her time and dedication. Matt's will go next.
Okay.
Jonas has got a bunch of stuff that he can wrap up at the end. Hello again. My next item is just an informational item to give you guys on the assessment policy for existing subdivision street improvements. This is kind of the other side to the first item we had tonight. This is for subdivisions that have already been built and 10, 15, 20 years later have fallen into disrepair and have never been taken over by NCDOT. They're still kind of in that limbo between DOT, the developer, and the homeowners. So the assessment policy now is, or what the board just implemented is, now homeowners and lot owners out there in that neighborhood can petition the Board of County Commissioners under North Carolina general statutes to basically front the money to bring the streets up to standard, have NCDOT adopt them, and then the county assesses all the property owners out there to repay that money. And again, it's written into the North Carolina general statutes. I think we might be the first county that's going to do this. We did some research and weren't able to find any other counties that were doing it, but it's in the legislation, and we're going to give it a shot. And again, this method should only be used when the original developer is no longer able to keep their commitment to maintain those streets and get it adopted by DOT. The basis of the assessment falls under Article 9, Chapter 153, A of North Carolina General Statutes. And the policy for the improvements, basically, 75% of the homeowners representing 75% of the lineal feet of road frontage in that subdivision must petition the county. So it doesn't have to be a unanimous petition, but it's got to be the majority of homeowners out there in a neighborhood that wants their streets fixed. It is acted on a case-by-case basis by the Board of County Commissioners, and the Board of Commissioners can decide for whatever reason they want to not to accept the petition, not to front the money. It's their call. But the first step in the process is that the Board of County Commissioners receive a valid formal petition. You've all got a sample of that petition in your agenda packets. I think it's page 42. And as you can see, it's a pretty involved petition. It's not just signing your name on the dotted line. It's got to be a notarized document and everything. They've got to present that to the Board of Commissioners. The board adopts a preliminary resolution. They state the basis of their assessment, and that's how each lot owner is going to be assessed when everything's all said and done with on how they're going to repay that back. And the Board of Commissioners have adopted their general policy pretty much for everyone is going to be each lot shall have an equal share of the repayment. There are different ways of doing it, but the commissioners decided that everybody, no matter what differences are there in lots, everybody's going to pay the same amount when they repay the assessment. So they adopt the preliminary resolution, and that kind of rolls into the construction phase. You've got a flow chart also in your agenda packet. It kind of takes you through the petition through construction, and that's the first half of this process. And then construction's finished, DOT adopts the road, and that rolls into the assessment phase of this process. The county holds another public hearing after construction, and then they finalize the assessment. It then becomes a lien on the property, and then it goes into repayment. The homeowners repay the amount of money that the county paid to have the roads fixed. And here's kind of a graphic of what I was talking about, the equal share. You know, no matter if the lots are all equal or if they've got different road frontages or sizes, everybody's going to pay the same amount as of right now. If the petitioners present a valid, good reason to change the basis of assessment, the commissioners can decide to do that. But it's generally going to be an equal share. That's pretty much the process. If you have any more specific questions, I'll be glad to take them. Otherwise,
From what I understand, these funds are limited.
yes, sir, Mr. Hardy. I think the commissioners, is it $200,000?
It's $200,000 this year. We're considering putting up $200,000 every year thereafter, and then the money will go back into a dedicated fund that hopefully it'll grow over the years.
Kind of hope it'll get self-funding.
Eventually.
I said that because I talked to a guy that one of the subdivisions here, I won't call the name, who said that they had got a price of what it would take to bring the streets up to DOT standards, and it was 250,000.
That's correct. A lot of these improvements they're significant costs to the homeowners, and that's kind of why this legislation is in there, because it is such a big amount of money for a group of homeowners to get together on their own. And we probably won't have a lot of subdivisions come do this, but there are a few out there that we know of that are going to try this.
I see that interest rate is 8%. That seems like mighty high to me.
That is, the interest rate has to be less than 8%. The commissioners can decide, and I hate I stopped on that one. The commissioners can decide whatever interest rate they want for repayment. It just can't be any more than 8%.
Okay, that's fine. I don't have
Yes,
to
sir.
clarify that.
It's great to have this policy, though.
Yes, ma'am.
It is really great, there's a start to help these people.
Absolutely. And Mr. Ross, also the next item down there, when the commissioners decide the final roll and publish the assessment and everything, they have 30 days, the homeowners have 30 days to repay it interest-free, or I believe the commissioners can also set a discount for prepayment
Okay.
if they so choose to. And that's, it was just an informational item. If there's any other questions? No? Thank you, Madam
Let me
Chair.
ask one question.
Yes, sir.
It's related. The committee recommended that the county commissioners consider petitioning the state to try to revise the DOT policy on, and I hope, they probably hadn't had a chance to follow up on that, but I would suggest that this board also go on record to the commissioners that that is an excellent recommendation, that I would think that a lot of counties would join
Yes,
Pitt
sir.
County with that. So I'd like to make a motion if it's in order.
And Mr.
We
Bradham,
endorse it.
let me clarify that was for the first item, the street maintenance guarantees. That was the street committee went along with the street maintenance guarantees. But absolutely, yes, sir, that was
Yeah,
part of their
that was in
recommendation.
their narrative of
Absolutely.
recommendation.
Yes, sir.
So I would make a motion that we also do that. Mom, do you agree with that?
But it's in there.
Well, yeah, it's in there from that committee, but I think maybe this board needs to do it too.
Well, we just accepted it, so I guess it's included,
Well,
didn't we?
It didn't
We
include,
accepted it as presented.
well, that was that's just a narrative of what their
Right.
process was. They were suggesting to the commissioners to pursue.
There was a secondary recommendation from the street committee, in addition to the language changes to the subdivision ordinance, that they lobbied the state to change how DOT accepts streets, how and when DOT accepts streets. Basically, they wanted to petition the legislature to make DOT adopt the roads earlier, and that was earlier rather than waiting for the density to fill out. And that was more of a it was a secondary recommendation.
It's not
in-
part of the ordinance.
Right, not part of the ordinance, but a more broad overall goal that the commissioners take a look at. And I think, Mr. Frank, you're recommending support for that recommendation.
Planning board show its
From the
support
planning
for that
board's perspective.
recommendation too.
If I could say, Janice Gallagher is working on trying to make this one of next year's legislative initiatives.
Absolutely. Did y'all hear that? It's going to be possibly one of next year's legislative initiatives. So,
I still, if we go on record saying yes to it, just adds more weight to it, so.
I'll second Frank's motion.
You got a second, okay. All in favor of the recommendation, raise your right hand.
okay.
Okay.
Thank you, Madam Chair, and I'll turn it back over to Jones.
One thing that's included in your agenda package is the Planning Department's work program for 2013 through 2014. Just to highlight some major activities, we have, of course, the street maintenance requirements that you guys are hearing tonight and will be forwarding on to the commissioners. There is an ongoing set of activities included in that work program that these requirements will require staff time to administer. Also, we have initiated our hazard mitigation plan activities as well. Pitt County is the lead agency on updating our hazard mitigation plan. This year it's a regional plan, which covers several adjacent counties. Pitt County has been grouped with Greene County, Lenoir County, Wayne County, and Jones County as our region. But Pitt County is the lead agency, so we have started interviewing consulting firms to put that plan together. Also updating the flood damage prevention ordinance. Community Development Administration, we've got several projects going on within our Community Development Administration. And also permitting and software updates, which deals with issuance of building inspections and that sort of thing. Other informational items. James, Eric, and Eli Johnson with our department is actually tonight in Winston-Salem at the annual conference for planning. We have been awarded the North Carolina Marvin Collins Outstanding Planning Award for the comprehensive planning dealing with large jurisdictions. That award was given to Pitt County through its efforts with their comprehensive land use plan, which you guys were a part of. They really, the committee that reviewed those nominations, were really impressed with the health component that our comprehensive land use plan included in it. So James and Eric and Eli are there receiving that award. Other items of interest is the 2013 North Carolina Housing Finance Urgent Repair Grant, as well as the CDBG or Community Development Block Grant. Initiation manuals have been submitted to the state, so we will begin rehabbing homes that qualify for those programs for urgent repair, and also replacing homes under the Community Development Block Grant. We are still in the business of leasing out properties for that we acquired after Hurricane Floyd. Those properties are being leased out at 10-year increments, so we are just finishing up our 10 years post-Floyd, so we're renewing those lease agreements with interested parties. If anybody is interested out that may be listening to us tonight, contact our office and we can let you know if those properties have a current lease or issue that came before you guys, I believe, a couple months ago, is a ETJ extension request by the city of Greenville. The commissioners did recommend or approve that request. It's now back to the city for its board to take the final action on to extend that ETJ. Ramshorn Solar Center, you may remember that rezoning request or conditional use permit request that came through. That project is taking a little bit longer than normal to get started. I believe word is they're going to go before the commissioners to request a time extension of 6 months to get that project on the ground. But they are planning on moving forward with that, is our understanding. Couple of budgetary items. We had an internship grant from the North Carolina Rural Center through the State Employees Credit Union that will, the county will receive $5,000 for internships through the county, and that's at no cost to the county. Another budget item is the $8,000 Vidant Foundation grant that Pitt County received. That's for its homeless program. That money will be used to provide dental coverage and basic health care coverage for our homeless population. Also, the commissioners dealt with the purchase for a portion of the Sadie Salter school property by DOT for a project they have going on. And as always, included in your agenda is the monthly report for May, June, and July, and August. And you're welcome to look through that to see what all we have been doing within the planning department. And as always, please visit our website to find out more about what we're doing, and feel free to give us a call if you have any questions. And that's it.
Thank you so much, gentlemen. Appreciate it. Is there any questions or comments, or?
I've got a question for planning staff. From Greenville Boulevard on 10th Street all the way out to Blackjack Simpson Highway, part of that's City of Greenville, part of it's, in the ETJ. I think DOT really needs to look at the speed limits out there. There are so many wrecks where all the student complexes are and up there by Bojangles. It's really dangerous. You have to really take your life in your hands going through that area some days.
Okay.
And down, starting at Lowe's, it's actually 55 miles an hour from there out. And that was changed a little while ago. It used to be 45. I don't know why it was, decided to up it to 55, but I think that needs to be brought back down.
Okay. We can communicate your concerns to DOT and get their input on why the speed limit was changed, and if there can be anything, or if they're looking at doing anything to address the traffic issues through that stretch. So we'll get back with you on that. Any other questions?
Concerns?
Yeah, I got one comment. We knew y'all were that good to get the reward. Just glad that the rest of the state decided to recognize it.
Well, James is very excited, and planning staff is very excited to receive that award, so.
Something to be proud of.
Quite an honor.
Congratulations.
Thank you.
So any comments, any other comments from the?
Hey, we just wish you the best, and hurry up and get over this aging out and age back in, please.
Well, I must say, I have thoroughly enjoyed serving these past 6 years, and you never know, maybe I might come back someday, but it'll give another citizen an opportunity to come and serve on this board. I have thoroughly enjoyed it, though, and it's great staff, and I say congratulations to the entire planning department for getting this award. It is a great reward and quite an honor. And James is really happy. I know he's happy for his entire department. And again, it's been good to serve our county here. And wish everybody on this board the best, and we'll be getting some new people, I'm sure, here. Okay? Do I have a motion to adjourn?
So moved.
All right, we are adjourned.